Hello, law students and legal practitioners. Today, we will dissect the case of Marynette R. Gamboa versus Police Senior Superintendent Marlou C. Chan, et al. GR number 193636 and decided by the Supreme Court on July 24, 2012. Let's begin. Here are the doctrines of the case. The writ of habeas data is an independent and summary remedy designed to protect a person's right to privacy in relation to life, liberty, or security, particularly against unlawful acts of information gathering, storage, and dissemination undertaken through improper or illegal means. For a writ of habeas data to issue, there must be a factual nexus between the alleged violation of the right to privacy and an actual or threatened violation of the right to life, liberty, or security. Mere allegations of reputational harm, embarrassment, or speculative injury are insufficient to warrant the issuance of the writ. The right to privacy, although fundamental, is not absolute. When it comes into conflict with a legitimate and compelling state interest, such as the dismantling of private armed groups and preservation of public security, it may yield, provided that the state action is lawful, reasonable, and undertaken pursuant to a valid governmental mandate. Intelligence gathering by law enforcement agencies, when conducted in furtherance of a lawful objective and within the bounds of authority, enjoys the presumption of regularity. The forwarding of information to authorized government bodies pursuant to official duty does not, by itself, constitute an unlawful intrusion into privacy. Facts of the case: Marynette R. Gamboa, then mayor of Dingras, Ilocos Norte, filed a petition for the issuance of a writ of habeas data against senior officials of the Philippine National Police, PNP, in Ilocos Norte. She alleged that she was subjected to unlawful surveillance and data gathering, which culminated in her classification as a person maintaining a private armed group, PAG. The alleged classification arose from investigations conducted by the PNP pursuant to Administrative Order No. 275, which created the Independent Commission Against Private Armies, also known as the Zenerosa Commission. This commission was tasked with identifying and dismantling private armed groups prior to the 2010 national elections. The PNP Ilocos Norte gathered intelligence relating to suspected private armed groups and forwarded the information to the Zenerosa Commission as part of interagency coordination. The commission later submitted a confidential report to the Office of the President listing individuals allegedly linked to PAGs, which included Gamboa. Gamboa contended that the information forwarded to the commission was unverified and unlawfully gathered, causing damage to her reputation and exposing her to surveillance. She sought the deletion and destruction of the information and an order restraining its continued use and dissemination. The regional trial court denied the petition for writ of habeas data, finding no sufficient showing that the alleged acts endangered her life, liberty, or security. Gamboa elevated the case to the Supreme Court via appeal by certiorari. Issues and ruling of the Supreme Court. Issue 1. Whether the petition for writ of habeas data was a proper remedy. No. The writ of habeas data was not proper. Under the rule on the writ of habeas data, the petitioner must show that the collection, storage, or use of information violates or threatens to violate the right to life, liberty, or security. Jurisprudence requires a concrete connection between privacy intrusion and these protected rights. Gamboa failed to demonstrate that the alleged surveillance or intelligence gathering posed an actual or imminent threat to her life, liberty, or security. Her allegations centered on reputational damage and speculative fear, which are insufficient grounds for the writ. Issue 2. Whether the alleged violation of the right to privacy alone warrants the issuance of the writ of habeas data. No. Violation of privacy alone is insufficient. The writ of habeas data is not a catch-all remedy for all privacy concerns. It is designed to protect privacy only insofar as it affects life, liberty, or security. Mere injury to reputation or honor does not automatically trigger the writ. The court ruled that even assuming intrusion into privacy, Gamboa did not show how such intrusion endangered her personal safety or freedom. The alleged harm was reputational, which does not fall within the protective scope of the writ. Issue 3. Whether the intelligence gathering activities of the PNP were unlawful. No. The activities were lawful. Police intelligence operations conducted pursuant to a valid administrative order and for a legitimate state purpose are presumed regular. Administrative Order No. 275 expressly mandated law enforcement agencies to assist in identifying private armed groups. The PNP acted within its authority when it gathered and forwarded information to the Zenerosa Commission. There was no showing that the data collection was done through illegal means or for an unlawful objective. Issue 4. Whether the state's interest in dismantling private armed groups outweighed petitioners' claimed right to privacy. Yes, the state interest prevailed. When a fundamental right conflicts with a compelling state interest, such as public safety and national security, the court must balance the interests involved. Protection against private armed groups is a legitimate and compelling governmental objective. The court held that the state's interest in identifying and dismantling private armed groups outweighed any alleged intrusion into Gamboa's privacy, especially since the information was collected pursuant to lawful governmental action. Thank you for listening and happy learning. See you again for our next case discussions.